defending the ANC perhaps will be sympathetic and want to listen because of its history of struggle against colonialism and apartheid. But individual, you do everything in your power to defend, not even the ANC, but an individual. And, you know, even reduce yourself to a point where you even appear unreasonable and running out of breath because you are so desperate to defend an individual. To a point that you even say, no, the president didn't know, and so on and so on. You want to say something, but you don't know what to say, but you have to say something. That's why you end up saying so on and so on in defense of an individual. I don't think that those who look up to you, the immediate and the distant ones, really are proud of you. Chairperson, some of us are leading political parties, and we're not just additional members or just members, we are leaders in our own right, and we could use our time to do organizational work if there's nothing here serious to be done in this parliament. And when we say we're leaders who are very serious, we led at a very early age. Some of us, our credentials speaks to themselves. We're not parachuted individuals. We grew up in the struggle, and we led, and we're still leading. So I want to make a firm proposal that we close the meeting and we go and take a legal advice. Because the reality is that we are not going to agree. And we don't want you to use, and all of us have agreed, including the ruling party, that we don't want to use those things of voting. So the best option available is that we close the meeting, we go take a legal advice on whether the remedial actions of public protector can be reviewed or not. I don't think we need a legal advice on the subpoena. We all agree that we can subpoena people here. But there is an argument from the ANC that from the look of things, they don't want to subpoena anyone here. That is going to be a serious point of disagreement because we're going to be rendered useless if we can't subpoena the president here to come and answer the unanswered questions. So the best option, Chair, without having to repeat what we said last night and again today, let's get a legal opinion on the remedial action, and then we also agree that in terms of the rules, we are allowed to subpoena people, and we exercise exactly that. There is no argument, Chair, that says we will be breaking any law if we call president to come here. And the president will not lose anything from coming to repeat, if he so wishes to repeat what he told the public protector. So I don't think there's going to be a genuine argument against the subpoena of people here. We are allowed by the rules of this parliament, and therefore we must exercise them. And if we fail to exercise them, we would have failed in executing and discharging of our responsibilities as members of parliament. Chair, I want to join you in the order you called about the so-called disruption of parliament. There is no such a conclusion anywhere. And to make an inference to it is just being silly. And therefore it is unacceptable. So let that matter be dealt with at a forum which is assigned to deal with that matter. And we must not maneuver issues here. People must come straight. If they want us, they will find us. Thank you.
Honourable members, there's a list of members of the committee that still want to talk to this point, but may I request that we start responding to some of the proposals also that has been made by members from the opposition. so that we can move to a point to decide what is the next step that we are going to embark upon. It's quite clear, Honourable Maimane, that there has not been much movement in terms of both positions. Both positions hasn't changed. We are still there where we were last night. And really, I want honourable members instead to restate what was stated yesterday, to start focusing now in responding to the different proposals that are on the table and come up with arguments that can really take this meeting forward. What I'm going to do is, honourable members, in light of the proposals also that is there, I do have the following speakers on my list: the Honourable Mocheka, the Honourable Gadi, the Honourable Shavambu, Honourable Kubai, Honourable Swart, Honourable Beekman, and the Honourable Dlakude. And let us stop there, instead of having another round of repeating what has been said before. Do you want to speak now? You are later on the list.
I think your suggestion was in order. Can you give us maybe a 5 to 10 minutes break and allow the ANC to caucus to look at the latest suggestions?
No. Give me a chance to chair.
Because we are rigmaroling.
No. Let us give the members of the committee the opportunity now to respond. We'll get to that point, Honourable Gadi. In fact, what I want to suggest is, honourable members, after the last contributor speaker in this meeting, that we will break for lunch. Right? We will be at that time on the program. And then I will also encourage the different parties who are here, the ANC and the opposition parties, to use the opportunity, if there's anything else that they would like to discuss with one another, to do so. Because we can't remain stuck on this point. Honourable Mocheka.
Honourable Chairperson, Honourable Maimane is talking about the supremacy of the public protector's reports. I just want to remind him that the office of the public protector and not the report of the public protector is a creation of the Constitution. So the Constitution created the office of the public protector. It did not create the report of the public protector. And also that the office of the public protector was created to support and strengthen the constitutional democracy. It was not created to be the fourth arm of state, and therefore the office of the public protector is not at the same level with the judiciary and parliament, and the public protector is not a judge. This parliament has been ordered by the Constitutional Court to amend certain laws, but the public protector does not have the same power to order this parliament to do or not to do something. Now, when we come to remedial actions, Honourable Maimane and Honourable Malema, I remember comrades because they add value to the work of the ANC. Honourable Maimane and Honourable Malema are simply saying remedial action by the public protector is sacrosanct, is non-negotiable. And of course, one is not surprised that they take that view, because they have already indicated that they don't understand the Constitution without legal advice from somewhere. Honourable members should know that you can bring 5, 10, 100 lawyers in one room. They are not necessarily going to arrive at the same conclusion. So if you say we must stop these proceedings and look for legal advice, from how many lawyers will we do it? Now, if we ask 10 lawyers and they disagree we come back with those 10 legal opinions, what are we going to do with them? I think the primary responsibility to find a solution to matters before us lies with this organ of Parliament. And I also want to say that, Honorable Melda, there is nothing we are doing that is offending the Constitution. We are actually exercising the powers and performing functions conferred on us by the Constitution. Similarly, the Public Protector produced a report as empowered by the Constitution and national legislation. So we as the African National Congress respect the powers of the powers and office of the Public Protector, but the report of the Public Protector is not the product of the Constitution. Only her office is the product of the Constitution. So it cannot be say the Public Protector's, if you challenge or you consider the Public Protector's report, it means you are violating the Constitution. That's wrong. But also we need to bear in mind that Chapter 9 institutions, all of them are independent, and that as Parliament we have a duty to protect their independence, but that independence is not an island on its own. They are independent but accountable to Parliament for their actions. So it is not out of order, therefore, for this Parliament to look, to consider the reports of all Chapter 9 institutions. We also have to bear in mind that the Public Protector did well by referring her report to Parliament, because she knows that Parliament is the national forum for consideration of matters of public interest. And the issue of Nkandla is a matter of national interest, a matter of public interest. We cannot accept a situation where anyone suggests that a matter of that national interest should come to Parliament for Parliament to rubber stamp that. We are not here to rubber stamp the Public Protector's report. We are here to consider it among other reports. And at the end of the deliberation, we will come to a determination ourselves, but we can't have a determination imposed on us from outside. And I think we also have to accept, Honorable Shibambo, that you see, when we interpret a law, the rule of interpretation says the maker of that law did not envisage absurd results. Now, to suggest that the maker of the Constitution envisaged that the Public Protector will have the same status as Parliament and the judiciary would be absurd, because the Constitution created only 3 arms of the state. The source of the power of the Public Protector comes from the Constitution as regulated by national legislation. And that legislation was made by Parliament. And you can't say Parliament made a law not knowing what it means, and that it must go and look for some legal advice somewhere on something that it did. We took a decision, we made a law, we know what that law means. We are not dependent on some lawyer from outside. Honorable Mulder, I think Honorable Bjekman said it in the clearest of terms, that there are commonalities between the reports. And if all the reports are dealing with the same issues, we cannot say one report is better than another by virtue of the office that produced the report. We have got to look at the merits of what each report is saying. And looking at the merits of what reports are saying, we are not in a position to say that the report of the public protector should enjoy a higher status. There's no basis for that. Honorable Maimane, of course, you have already pleaded guilty to not understanding the Constitution, and you are not able to move forward without a legal advice. But I can tell you that already here you have Honorable Swart, you have Honorable Bjekman, you have myself. We are lawyers, and Honorable Milder himself, and we are not sure that one legal opinion from one individual can have a higher status than what we collectively here can come to. So give us an opportunity. Give us...
No, honorable members, allow Honorable Macheka. I didn't interrupt you when you were busy speaking. Let's just allow the Honorable Macheka to continue.
Of course, you know, we should be tolerant, and I will tolerate everybody, because my interest is to make sure that the people of South Africa understand what we are doing here, so that when we come to conclusions, they can respect those conclusions. But I want to, Chairperson, go to a conclusion by saying the following things. Honorable Malema, I am not attaching or interpreting remedial action on the basis of what Professor Mtende Muhango is saying. I think when that professor went to university, I was already a senior lecturer who produced judges. There are senior counsels that I taught at UNISA over 10 years. So I'm not relying on him. I'm relying on my own knowledge of the law. I'm a doctor of laws. I was admitted as an attorney of the Supreme Court. I'm an advocate of the Supreme Court. So I'm able to make my own interpretations without reliance on some professor. So if you want to reject what he says, reject it, but hear what I'm saying. You see, when we interpret a law, we also look at the parliamentary records and other relevant documents. We look at opinions of legal experts. We look at other court decisions. On the interpretation of what the public protector is, I think one of a distinguished ANC scholar, Kada Asmal, can assist us here. He said the following, and I quote, "An independent and impartial ombudsman be established with expanded powers to investigate certain organs of state. Parliament used the name public protector, not ombudsman, because of the gender connotation concerning the term ombudsman. Now, I have already said that the framers of the Constitution envisaged a public protector who has the same status as the ombudsman. It's only a difference of the term, the name, not the content. If we use this to Professor Kada's interpretation and Professor DeFoss's interpretation, you will find that Honorable Malema said to us yesterday that the work make and take is not the same. It's not the same indeed, but I'll tell you that that distinction is not applicable in this case, because the public protector has the power to determine remedies and recommend those remedies to the appropriate institutions. So the report of the public protector before us has determined remedies and is recommending those remedies to us. That does not take out the authority of Parliament to consider those remedies and make its own determination. So we have the power and the jurisdiction to consider those remedies. The other thing is Honorable Maimane quotes the court judgment in isolation. What he said about the SC shows that he has not read the judgment as a whole. When you want to understand any document, you must read the document as a whole, and Honorable Maimane has not done that. Because in the words of the Supreme Court of Appeals, it says, while the functions of the public protector include those that are ordinarily associated with the ombudsman, they also go much beyond that. The public protector is not a passive adjudicator between citizens and the state, relying upon evidence that is placed before him or her before acting. His or her mandate is an investigatory one, requiring proaction in appropriate circumstances. Now, the only additional power that the public protector has is that she can be proactive, take the initiative, investigate, but the reports that emerges from that investigation is open for consideration by us, and that's what we are doing now. We are considering a report and not rubber stamping her report. Chairperson, I think you are so tolerant of us. I don't want to abuse that tolerance. I want to finish. I think, in short, Honorable Chairperson, as this Committee of Parliament, we have 4 reports between us. We have considered them, but there's no report that is higher in status than others. What we need to do is to look at the merits and demerits of the remedial actions of all of them and come to our own independent position. We are not here to rubber stamp anything. We are the highest forum for the consideration of national issues, and we are not an equal of the public protector. I thank you very much.
Honorable Gadi.
Hey. Yeah, no, Chairperson, this is traumatic. It's a torture, actually. But nonetheless, I think our colleagues there should be reminded of the House resolution of the 19th of August, amongst which it refers to Rule 138. And Rule 138A says, because the resolution says this committee shall perform its functions, amongst others, in consideration of its powers and duties in terms of Rule 138 of the Rules of Assembly. To summon any person to appear before it to give evidence on oath or affirmation, or to summon any person to produce documents. The President failed to produce a bond to the public protector. This committee now is seized with that function to request the president to bring the bond before this committee. So why are our colleagues there refusing to that we should call the president to comply with section 138A to produce the document, the bond? Why? Chairperson, I think we can speak here until we are blue. And it's apparently, yeah. No, until we are red. Until we are red. Until we are red. But all said and done, we cannot rehash all what we said yesterday. And apparently we are just at that point. And a firm proposal has been put here. Can we please adjourn and go for a legal advice? Our colleagues there are refusing that proposal. So what? They are refusing the president to come here and produce the bond papers and answer questions, 15 questions, 18 questions. They are refusing that we get an independent legal advice. In fact, Dr. Mteka there is quoting a quack professor of vets, Nkandla Mhango. In fact, verbatim in all his submissions since yesterday. In fact, he's taking brief from him. And we can't really be tortured by that views of that quack professor. I will pause there, Chairperson.
No, let me just remind honourable members, let us not reflect on individuals who are not part of the discussions in here. They're not in a position to defend themselves as far as being this or that. Honourable Shavambu, do you still want to make use of the opportunity?
Thank you very much, Chair. Do you know the limitation with when you're talking and then you throw in your credentials? I've got a PhD on this, I was a senior lecturer, and I was this and that, is that you run the risk of either misrepresenting those qualifications for yourself. And I think that Honorable Mutseka did excellently that, of misrepresenting the qualifications and the stones that he puts in his pocket to make a point which he can't substantiate. No one has said that the public protector's report cannot be reviewed. But we are not the relevant institution to review the reports of the public protector. It can only be a court of law that does so. That is basic legal principle, which as a doctor of law you should be knowing.
Producer of judges.
The person who has produced judges should be knowing that thing. It's a simple thing that we are supposed to know in terms of what happens. But also, yeah,
no, honourable members, you are now interjecting your own member. That's not good.
Now, also, it looks like, well, the Deputy Chief Whip does not know what is the mandate of this committee. She said it herself that we do not know what we are here for. I thought it was innocent. I understood when it was being said by the Deputy Chief Whip because I didn't expect much, obviously. But now, when the Doctor of Law says the same thing, that no, we're not here to just rubber stamp the public protector's report, which we're here to receive. We're not here to receive the public protector's report. Page 442 of the public protector's report says that the president should report to the National Assembly on his comments and actions on the report within 14 days. And then she gave a directive to the National Assembly that the president should report here. On the 19th of August, we took a resolution as the National Assembly, which was read by the Chief Whip of the ANC, that we're establishing an ad hoc committee to basically do three things. To consider the report of the president as directed by the public protector. That is what we are here for. That is the ad hoc committee's role. And make recommendations where applicable. We can't make recommendations on the decisions and the remedial actions that have been prescribed by the public protector because it is not applicable. It's a constitutional matter that can only be reviewed by a court of law. We can make recommendations on other issues, not on areas where the Constitution has got supremacy. And then number 3, it says that we must exercise the powers as per Rule 138 of the Rules Book. And number 1 in that Rules Book is that we have got the powers to summon any person. It's not the last option. It says all the aspects there of what we can do, but number 1, Rule 18 is that the powers of the committee is that we can summon whoever we deem can help the work of this committee to prepare a proper report moving forward. And we're saying that because this matter involves a president who has unduly benefited from a construction of a private residence in northern KZN, he should come and be held accountable here, because majority of the questions that he was asked by the public protector, by the special investigations unit, he has not responded to them. And we're saying that let us carry forward the work and the recommendations, the remedial actions that have been prescribed by the public protector. Now, the ANC opportunistically says that no, the public protector is not final, his recommendations. It's a constitutional interpretation which is being brought here. And the way out of this is to seek legal advice. I honestly think, I do not know what is the parliamentary word of saying it's sickness, but it's like that where you people say that Parliament can't seek legal advice. It does that every day. Even on legislation that have been discussed in committees and have been endorsed in the National Assembly, National Council of Provinces. Before all bills are signed into law, they are taken to lawyers to check if they are inconsistent with the Constitution.
And not to him.
Not to the doctor of law here, who is part of the lawmaking processes. That is what Parliament does every day. That is why we have got next to you, Chair, there a lawyer who is advising. Yesterday we received the legal advice.
Not from the doctor.
Not from the doctor. There is nothing sinister, there's nothing wrong with this committee seeking legal advice, which will, and of course people will have different opinions, but we're putting it to you that there is no sober legal mind, except the ones who are confused, who would come and give the interpretation which was given by the President of the Republic on what are the powers of the public protector, and which you are rehashing as the foot soldiers of the President. Because that is basically what you're doing, you're rehashing and cheerleaders of the President in terms of what he has argued the basis of the public protector's report. And we are saving you the humiliation. Again, it's free advice. Let's get proper legal advice. Let the lawyers go and consult, whoever they'll consult. They write the legal advice, table it here, and then we'll be able to entertain it. And if there is still a stalemate, we will, as interested parties, approach the courts to get a common interpretation of what is the legal standing and basis of what the public protector has said. And you must be extremely careful, because once the instruction is given by court that the money must be paid back, it's going to even have far-reaching implications. It's going to have far much more reaching. We proposed a modest, reasonable percentage of 90%. The court might say that actually reasonable percentage is 100%. Because that is what was stolen from the public purse. We're trying to advise you so that we can take the country forward and not back down by people who have unduly benefited from public funds and knowingly did so, because when they were cautioned during the course of that process, they did not heed to their caution. They turned a blind eye because it was convenient for them. Let's seek legal advice. Parliament does that every day. It's not for the first time. We cannot throw weights which are not going to help this process move forward. And we must not throw all sorts of things. We've got qualifications, all of us, but we're not going to be throwing them around every time we want to open our mouth and everything else. Let's make superior logical arguments, and we'll listen to that, not to what people claim that they know, and it's reflected in their arguments that they don't know what they're talking about. They're just being the drama majorities of an individual. Thank you very much.
See, honourable members, I said we'll exhaust this list. And I made the appeal to all honourable members to talk to the two proposals. And we must stay away from repeating what has been said before. I'm going to give the last 4 speakers now the opportunity, and I hope you will be pointed in your interventions. The Honourable Kubai.
Thank you, Chairperson. First, I think we need to deal with the issue of the rules. Rule 138, members shouldn't read it where it suits them and leave out where it doesn't suit them. Because if you look at the rules and if we are to apply them in this manner that they are simply saying it, it means we must receive petitions, representation or submission from interested persons or institution. We must conduct public hearings. We must permit oral evidence on petitions, representation, submission, and other matters before the determine its own process. So we must do all those things. That's what they are saying, because they are, no.
Honourable members, give the honourable member an opportunity. All of you had a fair chance to state your point. Whether you disagree with it or not is something else.
Chairperson, so when the rules and when the resolution refers to 138, and those who are experienced would understand that when a matter is referred and a rule is reflected, it says, apply the rule where it's applicable, where you deem necessary. And our argument is that summon any person to appear before it to give evidence on oath or affirmation or to produce documents, it's not necessary. That's what we are saying. So it shouldn't be that it's a must. It's not a must. The rules don't say that. So that's what I'm appealing, that we must read the rules correctly and apply them correctly. Now, the issue that the president stole public money, therefore it shouldn't be, it will be embarrassing that he will be told by court. There is no report that says the president stole public money. No report. Not at all. There's a difference between stealing. What is stealing?
Honourable Kubai, let's assist the meeting and address the chairperson instead of responding to interjections, please.
So there is nowhere in any reports that it says the president stole money from the public purse. So we should not come here and misrepresent the documents that we have in front of us. Neither. If an investigation, honourable member can go and start an investigation and produce evidence that the president stole money, because we don't have it. The other issue, you see, Chairperson, leopards never changes their spots. That we are subjected to insults here. I mean, the same thing happened to Mamana, a lady called to be speaking with fake accent. It's the same style. At that time, it was said, by the way, when people were apologizing, that it was president and the ANC that made them to say, but they're not in ANC today, we are still subjected to that. They even changed our tune. I don't know whether I speak like that. And whether it's an issue that it's an illiterate argument, I'm behaving as if I'm educated. Once we start talking about qualifications, it's another issue. But I'm just saying, it doesn't change. The leopard never changes its spot. The same insults. I've appealed even yesterday that if you disagree with what I say, you disagree with what we are raising, don't insult us. Anyway, we'll never stoop to that low. The issue of sensitivity. We are raising this thing, Chairperson, in terms of threats. We are not sensitive. It's caution that we are in a committee of Parliament. if members deem that this committee is not serving their purpose and they've already concluded that they want to approach the court, don't throw it here. Act on it. Because if you come here, come and argue your points so that we can engage on them. I'm not in a position to argue and engage on when people want to go to court. Unfortunately, unlike Tate Motshekga, I did other qualifications, not legal. So I would not legally be able to produce. Anyway, we are not even allowed to behave as if we are courts. We are not. So it shouldn't be thrown to us. That's what we are not threatened, it's a caution. But this is not what we are expected to do here. The issue again, Chairperson, I raised on remedial actions. You see, it's not about the opinions of legal gurus, but it's about the fact that the issue has not been tested in a court of law. No one can do it except the court. They want to reduce other people. Even the 16 September Daily Maverick, Perry DeVos reflected, while all of them argue on their support or against, all of them agree that this matter has not been tested by a court of law. All of them. None differs on that point. They go to support their argument for or against. So we shouldn't give an impression that it's one person in the legal field that disagrees with this matter or that says that this matter has not been tested in court. So, Chairperson, that's the issue here. And it can be that when one person feels that their viewpoint is not coming across, and then you say, no, my argument must be taken. It can be. All of us here have views. All of us here are expected to engage robustly. If we fail to convince each other, that's the nature of democracy. We are here to engage each other, find common ground. If we can't, we can't. That's the nature of democracy. It's the reality. So it can't be that because I do not agree with you and you start saying, no, your viewpoint must be superseding mine. And I can't do the same. You have your viewpoint. If you don't understand what I'm saying or you don't accept what I'm saying, you have the right to do so. If I don't understand and I don't accept what you are saying, I have the right to do so. It's part of democracy of this country. And the same issue, that's why I spoke about being labeled and all that. You see, it must not be in a mischievous way that when somebody says we take our mandate and therefore it's like we can't think. We do have our headquarters as Luthuli House. Broad mandates are taken from there because it is the African National Congress that contests elections, led by the Secretary General and the top 6 officials. We are deployees while we come here and uphold the Constitution. The issue here is that when you run and contest for elections, you put out to say, this is what we stand for. Who is the custodian to make sure that the manifesto of a party that has made that party to win election is upheld and the deployees ensure that what has been promised to the citizens is achieved? It's the Secretary General. So to come and continue to argue that the Secretary General, he has a duty to make sure that members of the African National Congress do not stay away from the mandate and of the people as voted in the election, but secondly, they stick to the manifesto. That's the role of the Secretary General of the organization. So his contact and his constant communication with us, it's not out of line because he has to make sure that what is promised to the constituencies is done. But secondly, and you see, that's the issue, nature of democracy, that when we stand here as members of the ANC, we argue points. And people can, because when I raise issues of, I've not been convinced, Chairperson, I continue to say it, that what becomes the role of the person that comes here. For example, let me get out of the president. Former Minister Jeff Deutsch, there have been articles that he contests what is here. He does not agree with the findings of the public protector. He does not agree with what is reflected against him. Then we call him here. And he comes here to say, this is my evidence. What the public protector did not go and investigate, this is concrete evidence in front of me that I'm tabling before the committee. And none of the members have clearly come out to explain what do we do then if we are to reach that point. And this is my argument, Chairperson, that I still don't agree that we should call anyone here. There are reports in front of us. They have issues of recommendations, all of them. Would have where we agree, would have where we don't agree with them. Would have to make observation as per the rules of the House and report to the House. Summoning people, I still maintain, is tantamount to calling of new evidence and starting investigation. That's another issue. You see, the issue here is even when people reflect that we are protecting an individual, that's not true. That is absolutely not true because we have come out to look at it. And we've said, where in the report, and I've read the paragraph that speaks about what is expected to be done, even on the president and on the actions. So the issue here, you see, tolerance as well, Chairperson, is part of what is reflected in the constitution of the country, that when people, that's why I said people never changes their spot, they remain who they are and will know them.
No, honourable members, let's not do this, really. Let's not do this. No, it's incorrect. No, honourable member, it's not correct what you're doing.
It is their nature.
No, honourable member, will you now start winding up, please?
Yes. That's why I'm saying we will know you by your spot. We have not changed. The issue here is that, Chairperson, there is nothing that says we must call anyone. We have the reports in front of us. Even a legal opinion is not going to resolve the issue that we want because it is the court that can pronounce on remedial action. It's only the court. Legal opinions can't, Chairperson. So we have a duty to conclude our work here. That matter is the territory of the Constitutional Court. No legal opinion will be able to solve that for us. Thank you very much, Chair. And I think I just appeal that members have tolerance. We listen to them, whether they speak something that we don't hear, we still listen. So they must do the same and listen.
Thank you, Honourable Kubai. The Honourable Swart. Let me also ask for the same levels of tolerance towards the Honourable Swart and others, the other two speakers that will follow. That has been requested. It's only correct, Honourable members, that we do give members a fair opportunity to be heard. So let's just be patient, even though we don't agree necessarily. Honourable Swart.
Chair, there are fundamental differences from a legal perspective on the remedial action of the Public Protector's report. The suggestion is, as we've done many times in the past, is to get a senior counsel's legal opinion on that issue that will give us guidance. I don't see anything wrong with that, and I'd fully endorse that. But secondly, if the ANC is not happy with that approach, we are awaiting a High Court judgment as we speak now. in the matter in the Western Cape where Judge Ashton Skippers is dealing with the exact action. And surely that is something that we could also consider. The honourable members are saying there's no court has decided on it. Well, the court has given an indication in the Mail and Guardian case. And that is why it's useful to even also look at that in response to what the President said, where he says the public protector is not an ombud. There the court has already said that the powers of the public protector go much broader than an ombud. So, Chair, there is that possibility. Now, I don't know the time limit of this committee. We know the time limit. We don't know when that judgment is going to come out, but at the very least, let's try and find each other. Otherwise, we've reached an impasse as we sit down. The opposition is firmly of its view. It's been constitutionally argued time and time again that the remedial action of the public protector is a finding that can only be set aside by a court of review. Even the government at one stage wanted to approach the court on this very issue and for some reason did not go on review. So, Chairperson, I'm not going to labor the point. I'm not going to engage one-on-one. I can engage one-on-one with Dr. Matsega's points. The one point about the office being separate to its reports, which I differ from. Obviously, the reports of the public protector must have the same sway. And there is a hierarchy and a status that is not the same as other reports. But we are going over the same issues. And so I fully support the views by Mr. Malema, by Mr. Shivanga, and by Mr. Maimani that we need to come to some end of this matter. We can't come back after lunch and then just continue going around and around. But would the ANC not find, at least at this stage, agree to a legal opinion? We've done it. I've been here 15 years. We've done it time and time again. We have differing approaches now. We are differing legally. Why not get a senior counsel's opinion? They can appoint the senior counsel even if you want to. Let's get some kinds. And in the meantime, we might then also have that judgment might come out, which will assist us as well. This is, as I started out, I said this is a very serious issue. It is almost a kairos moment for our Constitution. And I would again implore the ANC just to, let's find each other. Otherwise, we're going to reach an impasse right now. Thank you, Chairperson.
Honourable Beekman.
Yeah, thank you, Chairperson. Yes, Chair, I think the first point is, Chairperson, I think in the first instance, we as members of the committee and members of Parliament can't abandon our role in terms of Section 42(2) of the Constitution, namely to scrutinise and oversee executive action. And all the reports are before us are assisting us to ensure that we do exactly that. I mean, the past 11 hours and 15 minutes was spent on various topics and maybe just one chapter of all these reports. We as members of Parliament got a duty to the people who've elected us to consider all those reports. And the most important thing is what steps should we do to evaluate it? And I think that's the problem currently, or the impasse. We stated yesterday that the Cabinet memo of 2003 is really the gold standard to test the various steps in terms of the approvals of Nkandla, and then come to consideration to address the lacunas, to address the issues. It would not be productive at this stage, we believe, to single out one chapter or 1 or 2 pages and then make that the focus of the committee. We must go through that Cabinet memorandum in detail, looking at all 10 steps, and we haven't done it yet. And we'll have to go through that 10 steps and see what was the process, what was the role of the various players, and then come up with recommendations with regard not only to the officials, but to all the role players who was involved in that. That is our role. In terms of the review, a review doesn't arise at this stage. The committee hasn't done any recommendations. The National Assembly hasn't yet made any firm recommendations. So a question of the review at this stage, or opinion, is not at play. We as members of Parliament must do our work. We must go through the reports one by one. We must look at the instruments that was used. and evaluate that in that context. We can't source out now our role to do oversight and accountability to get a legal opinion. We must do the hard work, we must do the hard slog, and look at the reports, look at the various steps, what was the lacunas, and come up with recommendations. And also then analyzing the different reports. That's our role, Chairperson. So from our perspective, that's where we stand.
Honourable Maimane, you're raising your hand.
I am, Chairperson, because I find this...
Remember, there's still another speaker on the list, so I'm giving you the opportunity just to say exactly why it is that you're raising it. The Honourable Dlakude.
What is clear to me and very apparent is that the ANC isn't going to agree to a single thing. They don't want a legal opinion. They don't want a constitutional review. They don't want anyone to appear here. They just want us to run a read shop. Well, if it's going to be a read shop, then I think they must sit together and do it. I respectfully, Chairperson, request that we exit this meeting. We simply cannot proceed on this level. I'm sorry, Chairperson. We can't carry on at this level.
Order, honourable members, no. Members who want to leave the meeting are allowed to do so. Honourable Maimane, you've made your point. So those who want to leave the meeting are allowed to do so.
We are not leaving the meeting, Chair. We are no longer participating in this process of defending Jacob Zuma. We are not going to be part of those things.
Thank you, honourable members. Those who want to leave the meeting, you are allowed. You can do so. Honourable members, there was still another speaker that is left, the Honourable Dlakude.
Thank you, Chairperson. I think as the ANC, we are not media butterflies, so we are not playing to the media gallery just to sensationalize this issue. We believe that we are dealing with a serious matter here, and also that we are dealing with these reports, and what is expected of us is to continue with the work that is expected of us and come up with recommendations so that we can move forward on this matter. So, in these reports, Chairperson, there are commonalities and where the reports differs. So what we are going to do now, Chairperson, is to continue our work and come up with recommendation that is expected of us, recommend to the NA so that we can be able to finish what we have started, Chairperson. We know that as the ANC, we are not obsessed with anyone, and we know exactly that we are not paging anyone. We don't have any personal vendetta against anyone. We want justice to be done accordingly because of this looting and corruption that took place. I thank you, Chair.
Honourable members, I just want to, please, there's too much movement in this meeting now. There's a number of people moving in and out and falling around. Can we just resemble the meeting is still in session? And if you want to be outside, go outside and just close the door as you leave so that we can just bring this meeting to some form of conclusion. May I just indicate that according to the rules of the National Assembly, that a committee will continue to function for such a time that there is a quorum in the meeting. There clearly is a quorum in the meeting, and we will proceed under the mandate of the National Assembly to do what we are supposed to do. It is the right of members of different political parties who are supposed to be part of the meeting to withdraw or not to be part of proceedings if they so wish. We cannot force anyone to be part of it, but we can also not deny the meeting while it corrects not to continue with its business. So this ad-hoc committee will continue with its business. I've listened to the proposal from the Honourable Dlakude that we should start looking now at recommendations after spending 1.5 days, considering all these different reports, And we will then be in a position, once the recommendations are placed in front of us, that we will be able to produce a draft report that will have to be formally adopted by the committee as it corrects, and that is the report that will go to the National Assembly. Then we have executed our duties in terms of the House resolution that all parties agreed upon in the National Assembly. I also want to emphasize that right at the point when the draft resolution was moved in the House, there were already very stark differences in terms of the positions that the different political parties was going to take around the matter, right? And that once again crystallized itself in the meeting. There was also an agreement at the time, and honorable members and members of the public and the media who are here must be reminded that the first meeting that was called to elect the chairperson of the committee could also not proceed, and we had to wait for another 9 days before the committee could eventually elect a chairperson because of these very clear positions that the political parties have taken. One would expect that in a constitutional democracy, that while different people and from political parties, of course, that's why members are from different political parties, they carry different mandates, but Parliament is exactly the place where those different views must be put across. And that is the space that must be utilized. However, if any political party, any member of Parliament, or any member of the public feel that that space is not the correct space to exercise that mandate, then they are free to go and exercise it somewhere else. We cannot keep members of Parliament in a committee who clearly doesn't want to be part of it. The committee will now adjourn until next Tuesday morning at 10 o'clock, where we will then start dealing with the recommendations emanating from all these different reports that has been considered, and we will work throughout the day so that we can try to finalize the discussions around that. The committee is now adjourned. For those members who are still here and for those who have left, there is lunch that has been arranged in the restaurant next door. The media is also invited.